different law form that we can see from the off. So if we've got a guy who's got a conscience and he's saying, you know, I can see the needs of this person, so I'm going to offer my services, I'm going to grant my services to this individual and make sure that they get what they need for their own benefit. So the terms that we would be using within the trust relationship would be grantor, which would be the guy who's granting his services to the beneficiary who's getting the benefits. And when the guy is a grantor, he is then coming into the trust as a trustee, which means that he's the manager or the administrator of whatever the needs of the beneficiary may be. Or, for example, there may be a guy who knows that there's a need for someone to receive some benefit and yet can't do that job himself, so he will appoint or he will ask a trustee to act in his stead. So we have a grantor, which is a fictional term representing a party within the trust relationship. Then we have the trustee or co-trustees who are then going to manage the idea of what it is that's needed for the beneficiary so that they may receive these benefits. Now, there may be a liability of one of the trustees who's not performing his duty, and this is where the law looks down on the relationship. Now, one peculiar thing about equity and trust law is that no one needs to recognize that there is a trust relationship formed, because, hey, not everyone knows the law, but it doesn't mean to say that the law doesn't recognize the trust relationship. Now, it would take a party to understand the relationship, which is why if somebody went to a court because of the liability of a performance or an obligation that wasn't being performed, then there is now a liability that needs to be remedied. So we have a beneficiary who is expecting certain goods to be coming to them on a regular basis by way of the trustee at the order of the grantor. Now, we can assume that a trustee will carry out his duties for the beneficiary on good faith, and much of law is based upon religion, and religion is based on the philosophy of men. So people live through their philosophy. Like my philosophy is to, you know, contribute to my fellow man and to help build a more beautiful future for future generations. So that would be of benefit to others. So I'm acting as a trustee automatically by default for the benefit of others in a trust relationship that is in the future. So I've taken it upon myself to administer my duties and my obligations to others for the future, which others may or may not do. That's at their choice. And if the conscience speaks to them, then maybe they can see the validity in looking at it from that point of view. So, in the trust relationship, one of the trustees may have faltered on their duty. So now it will be the duty of the beneficiary to bring the failure of the obligation to light, and the grantor also has the power to take away the trustee's duty and reappoint or re-express the intent if the intent has been construed and is being represented wrongly, so that the beneficiary is not receiving the true benefits that they deserve. So that they are the positions within a trust relationship. We have grantor, which is also termed settlor, trustor, donor, and there are a few other terms that they use for this position. Then we have trustee, which will be manager, administrator, and he's accepting all the liabilities of the obligations to the beneficiary, which is also termed cestui que trust. And we need to have, in order for a trust relationship to be recognised, we need to have a transfer or an appointment or a contract, some sort of changing of hands of the trust property, which would be by way of a signature, an instruction, something that the trustee can say, well, I've received this, and it can be orally, and it needs to be witnessed and recognised in not only in public, but it needs to be recognised by the parties, even though the actual trust may not be recognised, but the specific property that the trustee has received in relation to what he needs to do, that needs to be recognised. So it may be an acknowledgement or a granting of, and there we have something that we can say is an intangible property which equity will recognise as something that is given, even though the parties may not recognise it. So that's something about the method of formation. So we have the crucial points of a trust relationship for it to be a bona fide trust are the intent and purpose of the grantor. So his intent will be for the beneficiary to receive benefits, and for the purposes because the beneficiary doesn't have the ability to sort of create those benefits for themselves, so they're relying on someone else to help them get on through life in a better quality of life. So we have these are the elements of the trust that need to be there for it to be recognised in law. So we have the intent, purpose, we have the property which was transferred to the trustee, so he has something to act upon for the beneficiary, and we also have the designated